Welcome to another edition of MissTrial, the hit podcast that talks about all things that are new in the world of law and politics. So much going on that it's hard to curate the topics for every episode. Just when you think that there is nothing going on and everything's slowing down, suddenly we have a blockbuster of a day, again, a week. It's hard to pick the topics, but just as luck would have it, today was the first time that the Jack Smith indictment, the January 6th case against Donald Trump, was on the calendar back in Washington, D.C. in front of Judge Danya Perry. And so we can talk about what happened there today. I look forward to talking that through with my two close friends, ex-prosecutors and current colleagues in law, Kathleen Rice and Danya Perry, and I'm Friedman Agnifilo, and we're just thrilled to be here to talk about that today, as well as what's going on in Manhattan, the Manhattan DA's office, and this bonkers news of Russia interfering with the election, these indictments coming out of your old office, Danya, in the Southern District. Wow. That is just crazy. And then, of course, as we're doing this, I see that Hunter Biden is entered a surprise Alford plea that took the prosecutor by surprise and didn't know about. I mean, just so many things going on. I don't know that we're going to have time to discuss that, but an Alford plea, for those people who are wondering what that is, I've only taken one of them in my whole career. And it's essentially you're pleading guilty without admitting guilt. And it's I don't know about in the federal system, but in the state system, it's very uncommon. And in fact, a lot of judges won't accept them. A lot of judges insist that you have to plead guilty. So it'll be interesting to see if that actually happens. That's kind of happening and developing right now as we are recording. So we can report back on that another time or do hot takes or something. But that's just such an interesting thing that everyone should keep an eye out on because it is so unusual. Have you guys ever done an Alford plea?
Not in 27 years practicing law.
Exactly.
A long time ago.
It's very, very rare and uncommon. So it'll be interesting to see what happens in that case. But let's focus on what we came here to talk about, which is mainly what happened in Washington today. The first time that the Jan 6 indictment was back on the calendar after it's been on pause, given the presidential immunity posture of that case. So just to remind everyone where we are, last summer, the special counsel, Jack Smith, filed this 40-plus page indictment charging Donald Trump with four counts of four charges, I should say. And it was a sweeping indictment. But then presidential immunity became an issue that was argued all the way up until the Supreme Court of the United States. Nothing could happen while it was being appealed. And in July, I think it was July 1st, the United States Supreme Court came down with a decision basically making new law and granting presidential immunity for any core presidential function. So anytime a past president performs a core presidential function, they are absolutely immune from criminal prosecution. Anything that is in their job description and even within kind of the outer perimeter of their job description, that gets the presumption of immunity that has to be rebutted by the prosecution. And anything that is unofficial, so personal, private, et cetera, that you can be prosecuted for. So what was going to happen with that indictment, with the Jack Smith indictment, was anybody's guess. Jack Smith agreed to postpone things for a little while. He needed more time. We were all scratching our head, but turns out he was actually busy going back into the grand jury, superseding, meaning changing the indictment and taking out all the things that were clearly that fall within this new law, this new immunity law. and paring down the indictment. The same 4 charges remain. Just some of the evidence is out, like the Department of Justice evidence. And we've talked about this on MissTrial numerous times. I'm just reminding everybody so that in case you don't follow these things and take notes as closely as we all do, I'm just summarizing it and recapping where we are. And the superseding indictment came out, and now today was the arraignment. And Donald Trump didn't show up for the arraignment, which was fine. He asked for permission to do that, and that was okay. Jack Smith agreed to that, and they entered a not guilty plea in his absence. He put that on a piece of paper, and they said that was okay. And then they discussed, this was essentially a scheduling conference, kind of discussing how are we going to deal with these new issues? What are we going to do? How is this case going to proceed? Will we set a trial date, et cetera? So that's what happened today. And it was almost 2 hours long. It was, Judge Chutkan is not, if anyone thought she was going to be cowed by the Supreme Court and somehow back down, she's not. She's absolutely ready to go. And what did you guys take from the hearing this morning? Talk to me. What did you think?
I mean, I thought, as you said, I like the term blockbuster. Kind of there have been some sleepy end of summer days, and now we're back to school and back in court. And Judge Chutkan took real charge of the courtroom from minute one. There were some pleasantries, and as you said, the former president was arraigned, pled not guilty in absentia, but then they got right into the meat of the case. And yeah, it was a process conference. It was procedural. It was to set schedules and all that. There were a couple of tantalizing nuggets in there. And I think we got a real flavor for the way that Judge Chutkan is seeing the case. And I think also we've got some clues that there will be more explosive developments in the coming months. So at the heart of this was, okay, well, what is going to happen next? And to set a little bit more of the backdrop, to add to what you said, Karen, the parties last week had to file what was supposed to be a joint report, a status report, a scheduling report. That was, the parties, and this happens all the time, the judge asks the parties to see where there are agreements and then, any disagreements. And here, the only thing the parties agreed on is basically this was a joint status report, and that, time could be told off the speedy trial clock because there are going to be motions made. That all was the only issues that were not in controversy. After that, the timing for sure, but even the sequence of what was going to be on the court's docket were hotly in contest. So the prosecution here said, well, the next thing that happens needs to be some briefing on this immunity question. And that makes perfect sense because it's exactly what Judge Chutkan had previously ordered. And it's what the Supreme Court said needed to happen. It also makes perfect sense because that is really the issue of the day. And the government made clear that it was ready to go and that it was prepared to file its brief at any time that the court orders. And they made clear again in the hearing today that they are at the ready. And they said they should go first. And the reason for that, typically where there are legal issues and a motion that the defense wants to make for dismiss, it makes sense that the defense will go first because they're the ones that have an issue. The prosecution filed its indictment. It filed a superseding indictment. Was it last week? It seems like a long time ago, but I think it was days ago. And so typically if the defense takes issue with it, they file a motion. But here, the government made the case, I think persuasively, I think Judge Chutkan did too, that they should go first. And the reason for that is because the Supreme Court ruled not just, as you said, Karen, it's kind of a newfangled immunity rule that, made new law. They did that both on kind of process, but also on evidentiary grounds. And they said that the government cannot even put in evidence that goes to a president's official acts. And so here, the government made the case that they need to be the first to go because they need to proffer, they need to put forward to the court for her consideration what it is that they are going to be putting into evidence. So there's the four corners of this indictment. It's now pared down, but it's the same four counts. But there's whatever it is, 39 pages now. But as is always the case, the government's proof goes well beyond the pages of the indictment. And as they said here, both in their joint status report and today at the hearing, that they've got plenty of proof and they're prepared to put that in front of the court and let her decide as a factual matter, first on the papers and then perhaps in a factual or evidentiary hearing. It's for her to decide what is and is not immune, both in terms of the charges and the allegations of the indictment, but also in the evidence that they're going to put forward. And that's where I think, it does make sense for the government to go first, and then the defense gets to pick away at that if they can, and then the judge gets to decide. And as is clear, the government is prepared to put in a bunch of additional information that we, the public and the electorate, has not yet seen. But what is very clear is that the defense wants at all costs for that not to be in front of the public, the electorate, before the election. And that was palpable in their joint status report. It was absolutely overt from counsel's comments today. John Lauro, who was the defense lawyer who was doing the arguments today, made very clear that, by his telling, if the government's permitted to put in this factual proffer, it would put what he called damaging details into the public record at this very sensitive time in our nation's history. That was his quote. And Judge Chutkan shut that down very quickly, very emphatically, and said the electoral calendar is not relevant here, and she cares about it not at all. And I think that was an important statement. And she is, not going to be driven by the campaign or the election, but on an orderly process of justice, such that every other defendant the criminal justice system gets. And so when Lauro complained about what he called a rush to judgment, the judge, I wasn't there to observe, but I in my mind's eye, she chuckled at that and said, this has been pending for over a year. We're hardly sprinting to the finish line. And so she's going to follow the same process that everyone else is. She seemed, by my read of it, seemed frustrated by the delay for sure, and wants to get this case back on track. So I have a lot more to say, but I want to pause because that was a mouthful, and see if anyone else had any takes based on kind of the process and the timing.
Well, Danya, I would just, as I'm listening to you, I'm thinking to myself, how can they possibly, with a straight face, make the argument that this is just too close to the election when it was their motion practice and their constant requests for delay that put them in this position? And, Donald Trump is really good and on message when he tries to sow mis and disinformation about the legal system into the public discourse. But in this instance, he is the one playing with the system. It's not, the system is trying to work. And yet he's taking advantage, of whatever he thinks he can take advantage of. And I just think it's really important to understand why would it be that they don't want, Jack Smith to do what he does very well, which is lay things out in a factual, evidence-based process way, motion practice, and put it out there for the public to see. And what's some of the stuff that's going to come out that they are desperate for the public not to know?
Yeah, what they were talking about was grand jury testimony, right? Secret grand jury testimony. People we'll get to see, whether or not Mike Pence testified before the grand jury, and maybe because the thing that's really the stuff that the judge is going to have to look carefully at and really parse is I think the Mike Pence stuff, that's the presumption. That's the area that is iffy, if you will, right? That the Supreme Court said, okay, that this had there's certain things the Supreme Court ruled is out. Anything with the Department of Justice. So Jack Smith took that out. And then there's certain things that are private conduct that was Donald Trump as candidate Trump, not as President Trump. But the Supreme Court said, look, the Mike Pence stuff could go either way, and we need to develop more of a factual record there. And I think that's what they were alluding to, that perhaps they will put the more Mike Pence information out there. So we'll see. Did he testify before the grand jury?
I think we know that he did testify, although, this case has been taken away from Judge Chutkan for like 8 months or so now. So this is like a distant memory. But Pence did testify in the grand jury, according to public reports. And so, yes, a lot of this fight, and this was patent in the conversation today, the colloquy before the judge, is that a lot of this, and in the joint status report, a lot of this is going to turn on Mike Pence and his testimony. I mean, the defense thinks that is going to be dispositive. And what they want to do is bite off little chunks of what will be in this immunity mix and trying to litigate it, seriatim in front of the judge. They want to say, well, let's put the Mike Pence piece first, because they say that would get rid of the whole case, which is not, I don't believe is accurate, and the special counsel doesn't. So they want to
explain why you don't think so. Why you don't think so? Because there are conversations that Mike Pence had as vice president with the president, and then there are conversations that he possibly had, or actions that he took when he was in his legislative role as president of the Senate. So you can just kind of go through that. I mean, I think that Trump is trying to kind of just make it seem like there's no other way for Mike Pence to have acted specifically on January 6th than as vice president of the United States in the executive branch.
Well, there's a third way too, and that's as don't forget
right.
Yeah,
that's right. As the candidate, that's true.
Yeah.
So which
would be private, or which would be unofficial. Right. That's just like anybody else running for office, right?
Right.
Any candidate.
That's it. That's exactly right. And the special counsel took pains to kind of elucidate this in the superseding indictment. They kind of classified Pence in his role as as presiding over the Senate, and made clear that a lot of this had to do with candidates, Trump and Pence, and a lot of it had to do with Pence's official role as the president of the Senate. And so that's kind of the legal question. And there's also going to be other fact-based questions, that are there other ways, not even, using the testimony of Pence, if for some reason the judge rules that was immunized, that the government can prove that there was this element of the fraud on the United States that had to do with the fake elector slate. And I think there are plenty of ways that are laid out in the indictment, in the superseding indictment, that could make the case that yes, Trump was involved in that element of the fraud as well, that would not rely on Pence, on conversations with Pence, or on official acts that he may or may not have taken with Mike Pence. So that is, there was some discussion at the hearing today where John Lauro, said that he believed that the Supreme Court's instructions to Chutkan were, quote unquote, crystal clear. And she objected to that as well, and said that she didn't believe that the Supreme Court had addressed details of how she was going to go about doing it. So there is certainly a lot for her to parse. And as we've discussed, a lot of that does turn on this question of, Pence's role, and whether any of it, was official, which, the Supreme Court seems to believe it presumptively was. But then if so, if the prosecution can contravene and rebut that presumption. And so it, did make sense that a lot of the discussion today related to that. But of course, there are many other allegations in there that don't turn on that, and many other ways that the government can prove its case that, again, don't turn on that. But that is, seems to be an order of first priority. But whether the judge will cleave that off from these other questions of immunity, remains to be seen. But it certainly would make sense. And it certainly does seem like that is another delay tactic that, typically, and as the prosecution said today, typically, there are motions that are made, they're made together. And then there's one appeal, because one thing everyone agrees on is that there will be an appeal of the immunity question no matter what. And so why have a bunch of different appeals in sequence? Why not do them all together? That's certainly the way that this is typically handled. And that is the way that this case should be handled.
That would be the most efficient. But the one thing that does tell us is this case is not going to trial anytime in the near future, which is why Judge Chutkan didn't set a trial date, because she said that would be futile given the fact that there will be appeals and it'll go back up to the Supreme Court one way or another. But immunity wasn't the only issue that came up today as well. I mean, what was clear was there are so many legal issues that Donald Trump's lawyers are going to bring up and continue to fight, because this case was on pause during this whole immunity thing. It's not like it would have been great if the trial court could continue on with these other issues while the Supreme Court was taking their time, frankly, deciding and making new law on immunity. But it's very much, there's all these other issues that are still outstanding and that need to be addressed. And that was also just, I couldn't believe it today, but that was part of what they were talking about, is what order is this all going to go in? For example, one of the other issues that they're going to bring up is this issue of whether Jack Smith was appointed legitimately, whether you can even appoint a special counsel, because
she kind of shot that down there, didn't she? Pretty much. I mean,
yeah, she seemed to find it absurd. I mean, she did say that Judge Cannon's decision in the Florida case, she did not find persuasive. That is one way she kind of betrayed, I think, her thinking about that. And then, very different than the Florida case, there is precedent that is binding on her in the DC Circuit. So the DC Court of Appeals has already decided this issue with respect, in that case, to Mueller's appointment, Special Counsel Mueller, back in the day, there by a Republican Attorney General and a Republican administration. But similar to Jack Smith, he also came from outside the DOJ. And so there's a lot of parallels, and the DC Circuit has already ruled on that, and she's bound by it. I'll just note that in the joint status report that was filed last week, the defense previewed this argument, pointing to Justice Clarence Thomas's invitation to Judge Eileen Cannon to dismiss the case on these grounds that the appointment was not lawful, and then she graciously took him up on that invitation. And they cite to her opinion and to that concurrence of one by the justice. But they failed to cite to the binding precedent in the DC Circuit, which is, but an ethical principle that they seem to think doesn't apply to them. But in any event, Judge Chutkan was well aware of this precedent and seemed to smack down pretty swiftly this notion that the appointment was not lawful.
I agree with you with one slight caveat. So the Supreme Court was looking at they were addressing the immunity question, and Clarence Thomas decided to, in his concurring opinion, essentially invite Judge Cannon, as you said, to rule, and gave her a roadmap on the special counsel's illegitimacy, et cetera, and not just Jack Smith, but all special counsels, essentially saying that appointing a special counsel from outside the justice system, as opposed to someone who's already like within the DOJ, that's not allowed, even though that issue was not before the Supreme Court. Now, the thing that I just want to just throw in there as a possibility. Yes, you're right that Judge Chutkan is bound by the DC circuit that is the law in the circuit. In other words, Judge Cannon's down in Florida. She's the same level as Judge Chutkan. When you have courts that are the same level, it's not binding precedent on them. It's only the appellate, courts that are above you, your boss. And so who sits above the DC circuit? The Supreme Court. And the one thing that the Supreme Court did in the immunity decision is chastise Judge Chutkan for not developing a record or a substantive record. And so she might, even though it's clearly binding law that a special counsel is appropriate in the DC circuit, she might want to at least allow the parties to brief it and make a record so that there is a record on this issue to go up to the Supreme Court rather than just summarily denying it as ridiculous, just given the state of play. I mean, this was even a few years ago. I would have just said, yeah, you're right. She'll just say, no, that's not even a thing. But the Supreme Court, as the ultimate kind of reviewing body here, I think you have to tread really carefully and not leapfrog or shortcut anything when it comes to them, because you just don't know what they're going to do. So even though I agree with you that this is going to go nowhere and she's going to clearly rule on that, I do think it'll still delay things because she might develop the record, even just on paper, but she might develop the arguments and develop the record a little bit more on that issue, potentially, given knowing that the Supreme Court is the ultimate audience here.
Yeah, I certainly don't disagree with that. I think she's definitely gonna, go, put the prosecution through its paces and make sure that, she makes a ruling that there is a threshold matter that she noted, which is that Trump probably already missed his deadline to file that motion to appeal. Because, so that has kind of languished, for some time. And Trump argues that things have changed since then, given, Cannon's opinion and the Justice Thomas Clarence's solo concurrence. But, it may very well be that as a procedural matter, his time has changed, because those things aren't really a change in the law, given that, one is the concurrence of one is not, of course, binding, and neither is another district court's ruling in a different district, even in that district. So, she may be able to do this on procedural grounds, which, I haven't really looked at, but seems like it makes a lot of sense. Just like any other criminal defendant, like you get an adverse ruling, you appeal it within the time you have to appeal it. Why, and so it may be that that alone is cause to deny it, but to be seen.
Yeah, so she said she'd give a scheduling order, I think potentially today or tomorrow, and the scheduling order, I think, will discuss exactly how she intends to handle all of these issues, right? How to handle the remaining issues that still have to be briefed in the case. But I think immunity is going to go first, because that's the threshold question, right? If you're immune, then nothing else can be discussed, because again, one other issue that will, if it survives immunity, okay, which is the kind of, because if you're immune, then there's no case at all, right? So like if the case survives the immunity question and that goes forward, and the case, the special counsel survives, right? If we have those two issues that will survive, and I think they will. Another issue that's going to be briefed is, how does Fisher versus the United States apply to this case? So that's the case where the United States Supreme Court held that 18 USC 1512, which is obstruction of an official proceeding, that as it applies to January 6th, that unless there's some kind of, that was a case that originally that charge was, or that statute was passed to deal with someone who's literally ripping up papers, that's what they're doing. That's how they're obstructing. And it's like documents and papers. And to use that in the January 6th context, Fisher ruled has to have some kind of physical or documentary obstruction. It can't just be, we stopped the proceeding. And so that impacts some of the Jan 6 cases and some of those convictions where that's the only charge. And of course, that's one of the charges against Donald Trump. So she's going to have, and Jack Smith was conscious of that in the new superseding indictment and actually talked about and put that in the indictment of how Donald Trump's obstruction of an official proceeding meets this Fisher standard. And so that is, that's going to have to be briefed as well as along with so many other legal issues that are still pending. I want to continue to talk about this case, so much more to talk about, but let's take our first ad break of our pro-democracy sponsors. I love our sponsors. They're the ones who choose us, right? We choose them, but they also choose us. They know what we're about and they want to support democracy. And so they're coming here and they're the reasons we can keep the lights on. So stay tuned, listen, and if you like their products, definitely support them because they're the reasons we can do this. Let's face it, after a few glasses of wine, the night out with my friends, I don't bounce back the way I used to when I was in my 20s or 30s. So let's face it, after a night out, I have to either make a choice. I can either have a great night or a great next day. But that's until I found Z-Biotics pre-alcohol. I love this product. It's fantastic because every time I have ever tried to come up with other ways to feel good the next day, it's getting harder and harder and harder as I age. I was a little skeptical about Z-Biotics at first because nothing else had worked, but I decided to give it a try. And I have to say, I had 3 glasses of wine the night before and I felt great the next day. I was very, very surprised. I kept hearing about pre-alcohol and wondered, what actually is it? How does it work? But now that I've tried it, I understand. And with their GMO technology that releases different products that help address these toxic byproducts that live in your gut, this is what helps you from feeling bad in the first place the next day. So join the movement of empowered women and others who are choosing Z-Biotics for fresher and more productive mornings the next day after a night out with your friends. Go to zbiotics.com/misstrial to learn more and get 15% off your first order when you use MissTrial at checkout. That's MISS trial at checkout. Z-Biotics is backed with 100% money guarantee. So if you're unsatisfied for any reason, they'll refund your money, no questions asked. Remember to head to zbiotics.com/mistrial and use code mistrial with 2 S's at checkout for 15% off. Thank you, Z-Biotics, for sponsoring this episode and for allowing me to continue to have good times out with friends. All right, we're back. And let's just wrap up Judge Chutkan and what do you guys? So what comes next?
So she'll rule on a schedule and on the process, and the sequence really, and I assume from the tenor of the hearing today that she is going to rule quickly and set a relatively quick schedule, but obviously only she and her law clerks know that right now. But I expect we'll see something pretty quickly from her, and then we'll know what universe we're in, whether it's in the Jack Smith's or Donald Trump's. So I think we'll be off to the races.
Yeah, I mean, it'll be interesting. She'll set a schedule. I mean, this was literally a court appearance to set a schedule is essentially what, I mean, it was substantive, but it's very much a scheduling conference of how are we going to deal with these issues? What's going to happen next? How are we going to brief these things? Who's going first? And what that tells me is we are a long way away from any trial. And she could still hold a mini trial that we've talked about, a hearing, right? I mean, she didn't even rule on that issue today. She could decide this on the papers potentially. I think we're going to learn that when she does the scheduling order, if this is all just going to be on the papers, or if there will be a hearing, if she thinks she needs to develop more evidence and a greater record. And I think Jack Smith was recognizing that by saying, I can attach more evidence to the papers, but we'll see. What was surprising to me is the defense asked for the mini hearing. They're the ones who said we should have a hearing. And that, I think, took a few people aback because that's the thing. It's after the election, true. But it was I thought that was really interesting that the defense is the one who said, okay, let's do a mini trial. I thought, wow,
but to be clear, they don't want to they don't want it before the election. They even said in the joint status report that had been filed before, they agreed, and they have to, that there needs to be some factual proffer. But they don't want it in front of the public. They had suggested that they get like a little private letter from Jack Smith, just to them, not on the record. Yeah, exactly. So it kind of really betrays the whole thing, Yeah. But yes, one way or another, Jack Smith is going to have to put out there what the evidence is going to be, and the judge will have to rule, does that or does that not contravene the Supreme Court's decision? And as you said, Karen, she is going to develop it in a very, very robust way. She does not want a series of remands back from the Supreme Court. She wants to develop it out, build it out, make a full record, make a full determination, and have the Supreme Court, one way or another, just say yes or no.
And just for people who don't live and breathe criminal indictments every day the way we have used to and still often do, indictments are by their very nature bare bones. That's a term of art that is used. You put the minimum amount in that you need to essentially make out the elements of a particular case. Now, this indictment is slightly more than bare bones. It's a talking or speaking indictment because there are conspiracies charged, but it still doesn't put forth all the evidence, the proof, the witnesses, what they're going to say, etc. So that's why, even though this indictment is 39 pages long and has a lot of detail, it certainly does not have everything, not even close. And so that's what the factual record is that we're talking about, that she would need to develop more of, and that everyone agrees needs to happen. It's just a matter of when and how and in what forum it happens in, whether it's in writing or in a hearing, et cetera. So that's pretty much, I think, everything on Washington, D.C. immunity and Judge Chutkan. The one thing for sure is we are not going to have a trial before the election. Not even close. So, the one and only is going to be, my old faithful Manhattan DA's office, the lowly state prosecutor's office, the why this case, the zombie case, all, that case has been called every name in the book. It's been called as not important. It's been, just so many people criticized it, but it's the one and only that will have held Donald Trump accountable. We thought he was going to be sentenced before the election, and now even that is in question about whether he's going to be sentenced. So let's just pivot and update people what's going on in that case. So there's really kind of two updates in that case. Number one is, of course, Donald Trump is trying to postpone the sentencing as usual, right? Does not want to be sentenced on September 18th. And Judge Merchan is going to rule literally any second, including could be while we are doing this, while we're recording this. Is going to rule on whether or not the sentencing is going to be postponed on September 18th. In fact, hot off the presses is a a letter that was just filed. I should say it was an email from the, it was just filed in the Second Circuit. It's from Judge Mershon's principal law clerk, Stephen Suhovsky. And it's to Matt Colangelo, who's the prosecutor, to Judge Mershon and their law clerks, to the defense attorneys, etc. And essentially, it was filed in the Second Circuit. This email, the email is dated actually Monday, August 19th, and it says, the court is in receipt of defendant's letter dated August 14th, seeking an adjournment of sentencing until after the presidential election. The court is also in receipt of the people's letter dated August 16th, 2024, that it did not oppose or consent to the defendant's application, but provided the court with factors to assist it when considering whether defendant's request should be granted. And this comes from Judge Mershon's law secretary. It says, the court will render a decision on this request on or before September 25th, 2024. Today is September 5th, 2024. So we are going to get a ruling today on whether or not the sentencing is going to go forward. Now, why was that filed in the Second Circuit? The Second Circuit is a federal court. Why was that filed in the Second Circuit today from a state court law secretary about a state court case? That's because what's going on in federal court is Donald Trump is once again trying to remove the case to federal court. Okay, he does not like this, that the case was prosecuted in state court to begin with, right? He tried to do a removal originally, saying, I'm a former president, I shouldn't be subject to a state court prosecution, I should have to go to federal court, and tried to remove it. And the reason he wants to remove it to federal court is in order to get into federal court, he has to make a showing that this was essentially, he was performing his job, that he was acting as president when he did these things, and therefore only the federal court would have jurisdiction over him. He also has to have a viable federal defense. And Judge Hellerstein ruled, he's a federal judge at the time, this was originally, that this was private conduct, and so this was not as president. And now that immunity has essentially used very similar language as language in the removal statute, essentially acting under the color of the authority of your office. You're acting as president. You're performing your official duties. You know, the type of language that gets you into federal court also gets you immune. That's why he's trying to go to federal court, because if he can get to federal court and show that threshold showing, guess what? He's immune. The case goes away. So he is desperate to go to federal court. So he is once again trying to remove the case to federal court. And that's what's been going on. And you know, his grounds for removal the second time around is, you know, the judge was biased against me. His daughter worked, you know, for pro-democracy, whatever it is, whatever the conflict of interest through his adult daughter that he tries to create. But then the second one, his other ground for removal was essentially that he essentially said that the court failed to conduct the proper pre-trial review of presidential immunity in light of the intervening Supreme Court decision, and that prohibited Trump from pursuing his interlocutory review of that decision. And I love what the judge said, which is, this court does not have jurisdiction to hear Mr. Trump's arguments concerning the propriety of the New York trial, which means this bias recusal issue. That's for the appellate courts. So he can appeal that. That does not belong here. So the bias issue is improper. And Hellerstein says, I won't review that. The only thing I will consider is his second argument, which was whether the Supreme Court's new decision on immunity requires removal. And what he basically said was, Hellerstein says, the Supreme Court held that a former president is entitled to absolute immunity from criminal prosecution for actions taken in the exercise of core constitutional powers. He's entitled to presumptive immunity for outer perimeter duties, and unofficial acts has no immunity. So, but then he goes on to say, this is what I love. Private schemes with private actors unconnected to any statutory or constitutional authority or function of the executive are considered unofficial. And I held in my order and opinion of July 19th, 2023, that hush money paid to an adult film star is not related to president's official acts and does not reflect in any way the color of the president's official duties. So he essentially basically says removal is not permitted, good cause is not shown, and I'm not removing. So that's what's been going on in the Manhattan case. And the third thing that's going to happen is by September 16th, Judge Merchan is going to decide how, if any, in any way, immunity applies to the trial, right? And what was any of the evidence that came in that case, should that not have come in, was that related to his official act? So that's what's going on in Manhattan. Crazy,
Yeah.
right?
Been busy and been kind of breakneck, right? Because the request, the notice of removal was just filed, wasn't it last week? Again, we're in this like weird time warp. I think it was just last week. It was first rejected by the clerk as being improper because it was a second petition. And then Judge Hellerstein really handily denied the notice of removal, and in very, very strong terms. So I don't even believe, and please check me because it's been a crazy week, all my kids going back to school, and but I don't think that the district attorney's office even responded to the notice of removal. Did I miss it? They had the first time around for sure.
Right,
And
right,
Judge
right.
said what I said before. But I think and we can correct ourselves. I can correct myself if I'm wrong, but I believe that it just, that he just very quickly denied it, on the grounds that nothing had changed, and he still believed that these private payments to an adult actress were purely private and unofficial, and that the intervening Supreme Court decision hadn't changed anything. So anyway, that moves along apace, but we'll see next week, on the 16th, I guess. We'll see today. That see, everything is just crunched. Today, if the sentencing will go forward on the 18th.
Yeah. So procedurally, on September 3rd, there was a notice of appeal to the Second Circuit because of the removal decision. And then on September 4th, the DA's office wrote a letter saying things don't need to be stayed. But I'm just looking at the procedure to see if they responded. Right. You're right. And they might not have.
I think they did. So they did on August 30th.
Yes, they did on August 30th.
Maybe that's it. It was just, less than a full page, and just saying, that was in front of Judge Merchan. See, everything is happening in real time. So, it's hard to keep up with it. But no, on August 30th,
yeah, Hellerstein, and you're right. Hellerstein went really quick.
Yeah, all they said to Judge Merchan in this one-page filing on August 30th was, hey, Judge Merchan, you don't need to stay anything pending the discussions about removal in federal district court. But in any event, so we have the decision, and now it's on appeal, and we'll see how quickly, if the Second Circuit intervenes before things move along.
The one thing Trump and his lawyers are good at, whether he wins substantively or not, is delay. Right? All these things he loses, but he succeeds in delaying things procedurally, right? And that's what keeps happening.
Yeah. Well, you know what else they're really good at is just kind of segues into this third issue that we're talking about today is they talk about, rigged elections. I mean, they do more to influence elections than anyone. And this recent announcement from DOJ with these indictments of these two Russian state media employees for allegedly, this is what it's alleged, that they funneled $10 million into a Tennessee-based company called Tenet Media with the specific intent to spread pro-Russian content across multiple social media platforms. The commentators linked to the platform include two conservative figures, both of whom conveniently claim to have been unaware of the Russian involvement. This indictment goes along with sanctions coming out of Treasury, the sanctions that were imposed on Russian entities and individuals involved in these influencing operations. I mean, it included the seizure of 32 internet domains that were linked to Kremlin propaganda efforts. I mean, the broader context here, this action highlights ongoing Russian disinformation campaigns aimed at sowing discord among American voters and promoting candidates favorable to Russian interests, particularly former President Donald Trump. Putin came out today after these indictments were announced and said, I actually support Kamala Harris. I don't think anyone believes that. But that's what he said. I mean,
Putin says he supports Harris?
That's what Putin said, today.
Oh, please.
Now, the Russian government...
Disinformation.
Exactly. It's just continuation. But the Russian government has been accused of using, fake news websites, social media bots, and multiple other means to amplify pro-Russian narratives, including, and I think most specifically, because I remember this when I was there, the opposition to, when I was in the House, the opposition to U.S. support for Ukraine. So the U.S. intelligence agencies are obviously, this is not the end of this. This investigation goes back to the end of last year, sometime in like November of 2023. And the intelligence agencies are still going to closely monitor election interference efforts. And the Biden administration has emphasized the importance of protecting election integrity through a combination of, not just indictments like these and sanctions like these that have been imposed, but bringing it to the public's awareness. Now, are MAGA people going to believe this, or are they just hearing more of what they want to hear? That's yet to be determined. But I think the more significant thing to look at, if you are prone to believing that this is just Democrats saying Russia, 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 and they just hate Trump, I think it's really important to look at what Republicans in the House have said. And I remember two of them. One I came in with, Ken Buck, who was a former member from Colorado. But back in November of 2023, November of last year, both he and, so Ken Buck was a Republican from Colorado who left at the same time that I did in 2022. Actually, he left shortly after. He got reelected in 2022 and left in 2023. But Ken Buck and Mike McCall, who is a Republican from Texas, and who most significantly is the Republican chair of the House Foreign Affairs Committee, both made significant comments about how fellow members of their own party were promoting Russian propaganda concerning the Ukraine war. And I think it's really important. I just want to summarize what they said. Buck, criticized hardliners in his own party for intentionally spreading misinformation and lies, not only about the 2020 election, the U.S. election, but also about Ukraine. And he has been vocal against the far-right faction that opposes U.S. support for Ukraine. But he went up against his party and highlighted that these members were misleading the public about issues like the stolen election and U.S. foreign policy. Mike McCall, good friend of mine, Republican from Texas, again, the chair of the Foreign Affairs Committee, he expressed frustration that Russian propaganda had, quote, infected parts of the GOP base, which made it harder to frame the Ukraine conflict correctly. He continued to emphasize that the war was not simply about NATO, but about Russia's broader ambitions to dominate Ukraine and parts of Eastern Europe. Obviously, he is McCall is a very vocal supporter of U.S. aid to Ukraine. But I think it's, we have to push back against this. Oh, it's just another indictment out of the Biden DOJ. I mean, there are significant and prominent Republicans who have criticized their colleagues in the House And they're buying into this Russian propaganda. So it's not just, unwitting people who are influencers who are getting fed information. And we don't have the time now to go into the specifics but this is it's going to be a continuing story and we can talk about it, but it's just a little more of the same. I mean, 2016, we saw that Russia was involved in trying to influence the election for Donald Trump. And in 2020, that continued as well as other foreign adversaries like China and Iran. But this is serious stuff. And I hope that people will, understand how important it is to get their information from reliable sources. And some of them have to be some Republicans. I mean, these are Republicans who voted when they were there with Donald Trump probably 99% of the time. And that's significant to note. But it is them saying, my Republican colleagues are spewing this Russian propaganda on the House floor in the U.S. In the U.S. Capitol. So this is to be continued for sure. But this is only going to grow now that we are only, how many days out? 60 days out? Is it even September, October, November? Not even. Almost exactly 60 days out. So I just think it's, again, we can talk about the specific facts of how they did this. But, it is a very specific attempt to sow discord in an already hyper tense, hyper politicized election year and, political environment for the U.S. right now. And by the way, they're not just doing it to us. They're doing it all across Europe as well.
I mean, anyone who people should go and read for themselves the reporting on this and the federal indictment, because it is beyond. I mean, when I read this, I couldn't believe how outrageous. First of all, the amount of money that is being made. Okay, and what they're saying is that these contributors, these conservative podcast and media contributors, kind of like us, they were unsuspecting. They were saying they didn't realize this was happening. Who knows? But they
wanted to be seen as useful idiots. But they kind of knew there were significant enough ties to the Russian government for them to know exactly where this was coming from.
I agree, but I'm trying to, giving them the benefit of the doubt, given what the reporting is hedging, right? And it basically, first of all, the amount of money that they were making, these useful idiots, if you will. One guy was making $400,000 a month plus $100,000 signing bonus as a performance incentive just for making 4 videos a week. Okay, I mean, unbelievable. Another unnamed commentator made $100,000 per video, according to the indictment, and it just the thing that really irritated me is apparently the Russians are mocking the United States and they're laughing about the fact that this happened, because they just look at us and just see, essentially how easy it was for them to launder money through us and get this message out there. And what they were saying was, it almost doesn't matter. They don't need to have tons of content out there the way they once did. They just need to get one viral video, right? They don't need to and look at how they get that out there so easily and use us as a country to get their get their information out there, and their propaganda out there. Anyway, it's just outrageous, but thankfully the FBI and the Justice Department is doing their job, but we have to stay vigilant and we have to be careful. And that's why we read everything ourselves, right? We're not going to ever be used as propaganda tools. We read these things ourselves. We do our own investigation. We do our own homework. And when we're offering opinion, we say it's opinion, but otherwise we give our we try to get the truth out there, because there is so much misinformation, disinformation. And, the one thing is, okay, yeah, the Russians do it and other bad actors that are against our interests, but it's also happening inside our country. I mean, that's what's happened. That's what MAGA is doing. And that's what the former Donald Trump, former president, is doing. That how many times does he come out and say something and then it turns out that it's a flat out lie, that it's that it's opposite of what you read in a court record. It's just unbelievable.
Well, and one of the criticisms, which is legitimate, is that this is an infringement on free speech. And there's a fine line. I think that it appears that they have made allegations that show that this is propaganda that does not, is not an infringement upon anyone's free speech, because it is a speech specifically meant to impact United States national elections. But that is what the other side would say. This is just a little more of the Biden administration trying to shut down media outlets that say things that go against whatever their, beliefs are.
Well, that's not true. They're being charged with a violation of the FARA, the Foreign Agents Registration Act, which means when you are a foreign government agent, you're spreading information in the United States, you have to register. And instead, they were using these guys from Tennessee, essentially, who are these right-wing propagandists who, by the way, they're not saying free speech. They're saying we didn't know. That's a big difference, right? They're saying we didn't know that we were being used. And so they're not saying, we can say what we want. They're saying
sanctions against Russian media outlets and stuff like that, that is,
true.
They're trying to sanctions and all that kind of stuff. I mean, just trying to give the full picture. Everyone can have their own opinion about it. But I think this case doesn't really implicate any free speech suppression issues at all.
I agree. Well, guys, we've reached the end of another great episode of MissTrial. I love doing this every week with you guys, and can't wait to see whether Donald Trump is going to be sentenced on the 18th or not, and what the schedule is going to be in Washington, D.C. And there's so much to talk about constantly. So we'll keep everyone updated, and we'll keep spreading true and real information on behalf of democracy. Great to see you all. Thanks for joining.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.